Corporations are people with their own religious beliefs. Let's play hardball. Good evening, I'm Steve Kornacki in for Chris Matthews. Let me start tonight with the big news out of the Supreme Court today. In a 5-4 decision, the court ruled that some for-profit companies can't be forced to provide coverage for contraception to their employees if it violates their religious beliefs. This was the first time the Supreme Court has ruled that corporations can hold religious views under federal law. Justice Samuel Alito writing for the majority, quote, "Any suggestion that for-profit corporations are incapable of exercising religion because their purpose is simply to make money flies in the face of modern corporate law. The HHS mandate demands that they engage in conduct that seriously violates their religious beliefs." All 4 liberal justices dissented. Justice Ruth Bader Ginsburg warned that the court had, quote, "ventured into a minefield," quoting from her dissent here, "in a decision of startling breadth. The court holds that commercial enterprises, including corporations, along with partnerships and sole proprietorships, can opt out of any law, saving only tax laws, they judge incompatible with their sincerely held religious beliefs, would deny legions of women who do not hold their employers' beliefs access to contraceptive coverage." The case was brought by 2 companies challenging the Affordable Care Act's contraceptive mandate. One of those businesses, Hobby Lobby, is owned by the Green family. They're devout Christians who say that they run the company based on biblical principles. The company has 13,000 employees, and it objected to providing coverage for emergency contraceptives and IUDs, which they consider a form of abortion. There was a strong reaction from the White House to the ruling. Your spokesman, Josh Earnest.
Today's decision jeopardizes the health of women who are employed by these companies. We believe that the owners of for-profit companies should not be allowed to assert their personal religious views to deny their employees federally mandated benefits.
On the other hand, conservatives celebrated the ruling. House Speaker John Boehner said, quote, "Today's decision is a victory for religious freedom and another defeat for an administration that has repeatedly crossed constitutional lines in pursuit of its big government objectives." For more, I'm joined now by Lori Wyndham. She's senior counsel for the Beckett Fund for Religious Liberty, which represented Hobby Lobby. And Sandra Fluke, a women's health advocate. She's also running for a state Senate seat in California. So, Lori, I'll start with you. The headline on this thing is, for the first time ever, the court is saying that corporations can assert some of the religious protections that are, previously said only individual people can assert. So I know that there are attempts here to carve out exceptions, to carve out sort of, well, you can't now be turning around and saying, well, we're not going to cover blood transfusions or things like that. But really, when you get down to it, when this ruling talks about sincerely held religious views of family-owned corporations, do we really know if there's going to be a slippery slope effect to this? How can we sit here and say right now that this isn't going to lead to similar rulings that expand this religious protection into other areas?
No, there won't be a slippery slope. The majority opinion was clear about this. They said that what the law requires is a balancing test. You have to balance the burden on religious freedom against the government's interest. Here, the government's interest was pretty weak because they've given a lot of exemptions and made other accommodations from this same law. In a different case, then that balance would very likely be struck differently. And that's what the majority of the court said.
But isn't it fair to say that we don't really know until this thing is tested, whether it's a future ruling by the Supreme Court, whether it's decisions by the other courts? We really don't know how this is going to be interpreted. I mean, I know there are some specific, potential cases that are cited in Alito's ruling. Again, I said like blood transfusions or something, but we don't really know who are we to say when somebody asserts, hey, this is my sincerely held religious view and I own a company? We won't really know until those challenges are brought. Isn't that right?
Well, I think that we have a really good example of this already. 8 years ago, the Supreme Court used this same law to carve out an exception for a religious corporation, a church, from the nation's drug laws. And then the Bush administration said, oh, no, you can't do this. The sky will fall. Everybody will get an exception. Since that time, we've had only 2 more exceptions made from our nation's drug laws under this religious freedom statute. So I think that that's a pretty good indicator that these kinds of decisions from the Supreme Court that are careful and narrow do not lead to a slippery slope.
Well, as we say, the justices in the majority insisted the ruling is limited in scope. Justice Alito wrote, quote, "The decision concerns only the contraceptive mandate and should not be understood to hold that all insurance coverage mandates, including for vaccinations or blood transfusions, must necessarily fall if they conflict with an employer's religious beliefs." But the decision does open the door for other companies to seek similar challenges. In Justice Ginsburg's dissent, she wrote, the court's expansive notion of corporate personhood invites for-profit entities to seek religion-based exemptions from regulations they deem offensive to their faith. So, Sandra, let me bring you in here, because Lori is talking about how in this particular case now, there is an alternative means for women employed by Hobby Lobby or any of these other companies who are affected by this ruling. There is an alternative means for them to get contraceptive coverage, and there already is an exemption to this law, to this rule that's in place for religiously affiliated hospitals, religiously affiliated universities, where basically the insurance companies provide the contraception. They're then basically reimbursed by the government. So in light of that, what's really wrong with this ruling? Why is it not as narrow as Lori is saying?
Well, because the court just merely says it's narrow. It doesn't provide any reasoning as to why closely held corporations, which is what they're dealing with today, should be treated any differently from publicly traded corporations. So we can very easily see that there will be cases coming which will expand which corporations it applies to. And moreover, when the court comes to the substantial burden test, it basically takes the plaintiff's word for it and says, okay, if you think this is a substantial burden on your exercise of religion, which we're still talking about a corporation exercising religion here. If you think it's a substantial burden, then okay, we'll agree with you that it is.
But Sandra, let me ask you though, from this, what would you say to it's a family-owned company, deeply religious, family-owned company, and they do have strong religious objections to the idea of providing contraceptive care, and at the same time, there is an alternative way to get women that contraceptive coverage. Isn't that, what's the objection to that?
But that's not really what we're talking about in the vast majority of the cases that this decision is going to impact. Closely held corporations are over 92% of our companies, and this is going to impact over 52% of our workforce, potentially. So when people think about small family-owned businesses, that's not who this applies to. This applies to groups like Dell or Toys R Us or the Koch brothers, Koch Industries. Small businesses, family-owned businesses, don't have to comply to begin with.
Isn't there also I mean, we've seen, Hobby Lobby right now has become, because of this case, has become sort of this, it's politically polarizing name. If you're on the right side of the spectrum, maybe you kind of like them. If you're on the left side now, it's practically become a curse word. For a lot of these large corporations, is there really the risk here of a sort of a slippery slope effect when the PR damage of taking on something like this? What major company is going to want to do that?
I think there's a lot of major companies that have an incentive to try to save costs, because we're not just talking about birth control. We're talking about a lot of different health benefits that can be quite high in cost, which is what's wrong with the court's argument when they say there's an alternative option here. There may be an alternative option in this case, but it's going to require government action to make this plan available to the women who work for these employers, and we don't have a guarantee that that'll happen. We know it'll be a big political fight, and I think there won't be that kind of option when we're talking about things like blood transfusion and other types of treatments.
Well, so Lori, let me bring you into that then. So this sort of solution that Alito recommends in the majority opinion here, this idea that already in place for employees of religiously affiliated hospitals, religiously affiliated academic institutions, where they object to contraceptive care, the solution that's in place right now is the administration basically set it up, as we said a minute ago, so that the employee then gets the coverage from the insurance company, and the insurance company is effectively reimbursed by the federal government. There's some relief given to some fees, and the insurance company is reimbursed by the federal government. Are you okay with that as a solution to this?
The government has never offered us that option. They have staunchly said from day one, no.
Right, but this is what Alito said. But we're talking about going forward right now with this ruling. In light of this ruling, and with Alito suggesting that, is that something you're okay with?
Right now, we have never been offered this option, and so that's something that, if the government offers, the Green family is going to have to consider whether that's in accordance with their religious beliefs.
So you're not the solution that Sam Alito is spelling out here, and sort of the justification for this ruling, you're not sure you're okay with?
Again, the government has never offered us this option, and so if they choose to offer this option to the Green family, that's something they considered. But so far, that's never been on the table. The government has simply refused to.
I understand it's not been on the table, but I'd say the world has kind of changed. Now we have this ruling, and not only do we have this ruling, we have a specific suggestion from Sam Alito that this is why the ruling is okay. We can do this because there's this alternative means to get contraceptive coverage. So I'm asking you now, if you have a problem with it, I'm picking up on some hesitation. I'm wondering, is that hesitation because do you consider that a backdoor way of taxpayers funding contraception?
You know, there's a lot of different ways that the government can go about achieving its goals. The accommodation that's mentioned is one of them. Title X is one of them. The government currently spends $300 million a year to provide contraception to women who need it. And so there are a lot of different options for the government to use here. I don't know which one they're going to choose. The Green family has simply asked that they be left out of it and that they not have to take part in providing drugs that could terminate a human life.
All right, well, Hobby Lobby didn't object to... Oh, no, sorry, Sandra, go ahead.
This points out the problem that we're doing incredible damage to our doctrine around religious freedom here and opening the doors to incredibly broad sweeping problems for other types of healthcare access and other employee protections. But what this is really about at its base is trying to figure out as many ways as possible to limit women's access to reproductive health care, because Title X, which was just referenced, there's been incredible fights to defund Title X, to cut off federal funding for family planning. We already have restrictions on which types of abortion and which circumstances can be funded by the government. There are states and the federal exchange where people cannot even use their own private money to purchase insurance that covers abortion. So this is, from all angles, an attempt to limit affordable access to reproductive health care. And there's a reason that conservatives won't agree to this type of a solution, because they're going to fight it politically.
All right. Well,
the Green family
very quickly, Lori, we got to get, but quick response to that.
Hobby Lobby has never objected. The Green family has never objected to their employees going out and obtaining contraception on their own. That's not what this is about. This is about whether the government can force them to be involved.
All right, I want to thank you. Leave it there. Thank you to Lori Wyndham and Sandra Fluke.